Good afternoon. This is Emily Sumner of Sumner Immigration Law, and I'm happy to host this month's webinar that is called Family-Based February. We haven't done a lot of webinars, at least in the past year, on family-based processes, so we're happy to share this information with you. Before we begin, someone or all of you could message me in the chat and just let me know that you can hear me, I would appreciate that. Awesome. At least one person can hear me. Wonderful. A couple people can hear me. Great. So we will go ahead and get started. Thank you so much for joining us today. Before we get started officially, I want to let you know that this webinar is being recorded, and we will share this recording with anyone who has registered for the webinar. So if there's something that you don't catch, then we will send you the recording so that you certainly will have that information. An overview of what we're talking about today. The family-based topic is a huge topic, and I'm not able to go into a lot of detail on every single option. Obviously, within the span of, I plan for this to be about 45 minutes. I want to save some time at the end for questions. So obviously I can't go into every aspect. We are happy to have additional webinars in the future that go into more detail on specific topics, if that would be helpful for people. But it is going to be very, very high level. I'm also going to try to focus on information, or rather current processing, that is maybe not available online. As you may know, there's a lot of information online. Not all of it is accurate, but there's a lot of information online about different family-based processes. So I'm going to try to give you information that is not as accessible and that's helpful for in the moment processing. So we'll start with Biden's executive orders, what's happening with those and what is not happening. Then we'll look at a very high level overview of immigration options for spouses, and then immigration options for parents, siblings, and other relatives. Then we'll move into some very not general, but some high level tips for processing, or rather for filing family-based cases. And we'll talk about processing timelines and trends, what we're seeing in real life right now on the ground. Before we proceed to the Biden's executive orders, I want to remind you that this webinar is for educational purposes only. It is not legal advice. I am not able to answer very detailed fact-specific questions. That's something I'm happy to help with through a consultation where we can talk one-on-one about the specific details of your case and make sure that I'm giving you correct information for your specific situation. Finally, please ask more questions. I have tried to organize the information in this webinar around the questions that you also helpfully submitted. But ask more questions as we go along, or at the end. You can put your questions in the chat and I'm happy to answer them as we can. So with that, let's move to our first topic, what's happening with Biden. Biden took office obviously on January 20th, and everybody, I think, in the immigration community is expecting wonderful things to come from the Biden administration in terms of changes to immigration law. We've had kind of a rough go of it the past 4 years. And before that, you know, every administration is different and has different policies. But definitely the past 4 years have not been immigrant friendly or foreign national friendly. So we're hoping for great changes. And we really, what I heard as an immigration attorney in the media is that Biden was going to have Immigration Day, and it was going to be on Friday, January 29th. And we were very excited. Everyone in the office, we're all working remotely, but we all ordered Starbucks. We're very excited. And then nothing happened on the 29th, or very little happened immigration related. The agencies or the administration said that they were waiting for Mayorkas, who is the head of the Department of Homeland Security, which oversees USCIS and other immigration-related agencies, or is the umbrella agency. They were waiting for him to be sworn in, and that hadn't happened. And then there was snow in the DC area, so it was delayed a little bit. So finally, on the 2nd of February, we had kind of an Immigration Day where we had some executive orders. For me, honestly, it was disappointing. I think it was, I need to probably ramp down my expectations. We're not going to be able to undo 4 years worth of executive orders and policy changes and just processing trends within the span of a couple of weeks. That's just not realistic. And the administration has other things to do as well that are not immigration related. So I think I just have to, all of us have to, if you haven't already, have to have realistic expectations about how long change is actually going to take. That being said, we have had some positive changes so far. Even in the first almost month of, let's say 3 weeks of the administration. The first huge change came immediately, first day that he was in office, and that is he rescinded the Muslim ban. So the Muslim ban, you may remember, and that's kind of a street term, if you will. It's not the official term, but there was a proclamation or executive order that in 2017 that Trump implemented almost as soon as he was in office that prohibited foreign nationals from certain countries from entering the United States. There were several different iterations of this executive order. Obviously, it was litigated over the years and changed over the years, but it still was in place when Trump left office. So Biden did get rid of that immediately, and we're thrilled. We have clients who have been affected by that, and we're very excited that they can move forward. At least they can move forward because that has been rescinded. There are other reasons they may not be able to move forward as quickly as they'd like to, and we'll talk about those reasons in a few minutes. Secondly, undocumented foreign nationals will be counted in the US Census. Third, he issued an executive order that says that work on the border wall will be halted. The Department of Homeland Security, he issued an executive order, and this happened on February 2nd. He issued an executive order asking DHS to take actions to, quote, preserve and fortify DACA. DACA is Deferred Action for Childhood Arrivals. That's what it stands for, and it benefits certain foreign nationals who meet certain requirements. DACA was put into place through executive order in the Obama administration, and then has been through some tumultuous times. But anyway, Biden has signaled that he supports that program and wants to preserve and fortify. We're not sure exactly what that means yet, but that's a good sign for any DACA holders. And then finally, he issued an executive order, and I think this is part of what I was disappointed with, to be honest, on the second, that he ordered an executive order that required a, quote, top to bottom review of recent regulations, policies, and guidance that have set up barriers to the legal immigration system. That includes the public charge rule. When I say public charge rule, I'm referring to the rule that Trump put into, it's a regulation that the Trump administration created while he was in office that requires, among other things, the Form I-944. The Form I-944 is required for most foreign nationals who are applying for permanent residence in the United States, meaning they're filing the I-45 adjustment of status application here in the United States. The I-944 is an 18-page form that requires extensive documentation of a person's financial history, including their household income, the amount of debt that they have. The form asks for their credit score and credit report, which many foreign nationals don't have for various reasons. It asks for education information and information on the education that the foreign national holds, information on whether the person is fluent in English, whether they have health insurance, that type of thing. So it's extensive documentation, also assets and liabilities and tax return information. So it adds hundreds of pages, honestly, to this process and lots of hours for both the attorney and the person preparing the case or the foreign national who's going through the process. So we were hoping that the Biden administration, I wasn't optimistic that it would be gone immediately as soon as he takes office, because it is a regulation. So that means in order to, quote, undo it, the government has to go through the Administrative Procedures Act, which is a statute that outlines how the government goes about making regulations. However, I was hopeful that the Biden administration would come out and say, this is not something that's required, and we're going to take actions as soon as we can to get rid of it. That's not the wording that was in the executive order, and that was disappointing because it says he basically ordered a task force to take a look at that policy to see, or the regulation, to see whether it's required or not. So we'll have to see going forward what happens with that. But for right now, it is still in place. The I-944, the Declaration of Self-Sufficiency, is still in place right now as of today. I always tell clients when I'm talking to them, today, if you were to file today, it's required. The reason I say that is it is being litigated. It has been in litigation for at least over a year now. So the different federal courts make different decisions at different times, and there have been times over the past year that we have filed on a day that it's not required, and then literally the next day there's another court decision and it is required. So it's created a lot of chaos, I will say, for the adjustment of status filings. Just trying to figure out, is it required, is it not required? We don't want to do it, obviously, if we don't have to, but it is required now. We are receiving requests for evidence for cases that we filed on a day that it was not required. So we're having to submit that information now. But just know that it's possible that that will change in the future, but it's not guaranteed, and we don't know exactly when that will change. Other aspects of the executive order that he has put out, it's a pretty broadly worded executive order. As you can see here, top to bottom review of recent regulations is pretty broad. Policies and guidance. So we hope that the administration, and I do think that they will take a look at these and work to overturn or rescind some of the regulations, undo some of the regulations and policies that are in place that prohibit or put a hamper on legal immigration. But like I said, it's going to take time and we have to be patient, which I'm not very good at. I don't know about you. What has not changed with the executive orders? The proclamations 10014 and 10052 have not been rescinded. Those are still in place, and we are waiting to see what's going to happen with those particular proclamations. Those proclamations are proclamations Trump put into place in April of 2020 for the 10014 and in June of 2020 for the 10052. And they prohibit the entry of certain foreign nationals into the United States, specifically pretty much foreign nationals who the 10014 prohibits the entry of certain foreign nationals entering on immigrant visas, which are permanent visas. So if a person, let's say a family member or an employer sponsored you for permanent residence, then at this time, unless you meet certain requirements, exceptions, you wouldn't be able to have the visa granted and enter the United States. The second proclamation, 10052, is about non-immigrants. It prohibits the entry of certain non-immigrants, like people on H-1B and L. So that is, both of those are in place. They are supposed to expire at the end of March, and we don't know what's going to happen. In other words, we don't know if Biden is going to say, yes, I'm going to extend those, or just let them lapse and let it go. The other thing, it's not on here, but another thing that has not changed is the travel proclamations, the COVID-related travel restrictions. You may remember that when COVID first hit, the Trump administration implemented a proclamation prohibiting the entry of certain foreign nationals into the United States coming from certain areas of the world. So a lot of the European countries, Brazil had that restriction, and that is still in place. And it's changed a little bit. The wording of it has changed a bit, but it is still in place. In addition, South Africa has actually been added to that. That tells us that Biden is concerned about the COVID virus, I'm glad that he's concerned about that. I'm glad he's taking steps to try to mitigate the spread of that virus. But it does affect the ability of our clients and for our national community to be able to travel and enter the United States. That's still in place, and I don't expect that to change at any time. So regarding travel, and we'll talk about this a bit more, but regarding travel and entering the United States, whether you're entering the United States as a non-immigrant or as a person on an immigrant visa, depending on your situation, and it's complex. There are a lot of exceptions, and there are exceptions you can apply for, and some are written into the proclamations. But there are a lot of exceptions. You have to look at multiple factors. First is, are you able to come into the United States, or are you affected by the COVID related travel bans? Then you would look at, are you permitted to come into the United States because of these proclamations, the 10014 and 10052? Do those affect your ability to come into the United States? And then finally, if you are able to come into the United States, or at least meet an exception or a requirement, is the consulate open? If you have to have a visa stamped in your passport, whether it's a temporary visa or a non-immigrant visa, sorry, temporary visa is non-immigrant, or a permanent immigrant visa, is the consulate open? And are you able to get an interview there in a timely manner to get the visa that you need to enter the United States? So there are multiple factors that you have to take into account if you're planning to come to the United States. And those are all things that we can help you with. We advise clients on that on a daily basis. As I mentioned on the previous slide, the public charge rule is still in place, so that has not changed as of right now. That is in place. And then finally, there is no quote unquote new law. I have had a couple of clients email me and say, what do I need to do under Biden's new law? There is no new law. You may be referring to the fact that on the day that he was inaugurated on January 20th, he sent to Congress a bill that would reform the US immigration system. It was a pretty comprehensive reform bill, but that has to be passed by Congress. So that's going to be a process. It is not in place right now. There is no information other than the bill itself. I am not advising people to take specific steps right now to prepare for that, other than things that I would advise anyway, like make sure you're maintaining status if you can in the United States, make sure you're paying taxes, that type of thing. But there's nothing, please, please, please do not pay money to attorneys or anyone else who say that they're going to help you prepare for the Biden's new law, because that's not a thing that exists right now. It has to be passed by Congress. That will take lots of debate and interaction with Congress. Both houses of Congress, the Senate and the House of Representatives, would have to pass the bill. If there are differences between the bills, they would have to be reconciled, and then it would be sent to the president. The likelihood of this passing, I think that as it stands right now, personally, I don't think it's very high. I think that it's so comprehensive that I don't think that it will be passed as it is. I think that it's possible that certain aspects would be passed, either just one aspect or multiple aspects over a period of time, but I don't anticipate that that would be passed right now. That doesn't mean things won't change. I think overall with Biden, what I haven't talked about with changes with Biden is the overall atmosphere, I think, for foreign nationals in the United States, I hope, is more welcoming, and there's more hope. It's not this, I think with the previous administration, there was this, I felt it, lots of anxiety for foreign nationals, and you're not sure when the policy is going to change. And it's just wasn't very welcome. It's like setting up barriers, literally and metaphorically, to prevent legal and undocumented immigration into the United States. And that's, I think we're in a whole new world now. If you look at Biden's immigration plan, his bill, some of his executive orders, you do get a sense that he wants to set up a welcoming environment for foreign nationals into the United States. So yes, we have to follow laws and regulations and rules, and it's going to take a while to make changes, but it is a much more welcoming environment. So I'm really excited about that. And it's fresh new energy that we're very excited about. So we're moving on to family-based options. As I said, this is going to be very high level, and you all please let me know if you have questions as we proceed. Put them in the chat box here, and I'm happy to address questions as we go on, or as we go through this, or at the end. So marriage-based options. There are three major marriage-based options. Again, keep in mind, this is high level. This is not a how-to file on your own at all. But there are three major options for marriage-based cases. The first is a fiancé visa. The second is what I call I-130 and consular processing. You may hear me or other people refer to an immigrant visa. If you go through this second process, the I-130 and consular processing, you would obtain an immigrant visa at the US consulate. And then the third is the I-130 and I-485. The choice of which option, which path to go through, depends on several factors, some of which are listed here, but not all. And that's definitely something that I talk to clients about every day in consultations, trying to help them figure out what their best strategy would be for marriage-based and family-based immigration, as well as employment-based, which we're not talking about today. But the first one is the fiance visa. So let's talk about who can do this, who can go through these processes. With the fiance visa, the petitioner, that means the person in the United States, or they don't have to be living in the United States, but the person in the United States has to be a US citizen. Green card holders cannot sponsor their fiance for the K-1 process. For the I-130 process and for the I-130 and consular processing and the I-130 and I-45, it is possible for a green card holder to sponsor them or a US citizen, either one. So that's one thing to keep in mind. If you're a green card holder, you're only looking at the center column or the right column. Secondly, you would need to think about what the process is. What is the process going to look like? How many steps are there to the process? What is the timeline? So with the fiancé visa, the first step is filing the I-129F petition with USCIS. Once that is approved, it is forwarded to the US consulate in your home country, where the foreign national partner in the relationship would have an interview and obtain the K-1 visa. When they enter the United States, they would have 90 days to marry the US citizen who sponsored them, can't marry anybody else. And then the foreign national would file the I-45 application for adjustment of status to become a permanent resident. So that's the very high level overview for the K-1. As you can see, there are lots of steps involved, or there are 3 major steps involved with the K-1. And I would say from the time, we'll talk about timelines a bit later and a little bit more detail, but I would say in general, and this is super non-committal statement from me, in general, before COVID, from the time you started the process to the time the foreign national was able to enter the United States before COVID was around a year, maybe a little bit under a year. But then once they're here, they have to file the I-45, and that process can take another year. And we'll talk, like I said, about timelines again in a few minutes. With the I-130 and consular processing, it's also a combination of filing through USCIS and Department of State. The US citizen or green card holder would file what's called the I-130 petition with USCIS. Once it's approved, it would be forwarded to the National Visa Center, and then they would gather the documents and fees. Then it would be forwarded to the US consulate for the foreign national to enter apply for the visa and enter the United States. This, again, they would apply for what's called an immigrant visa. That means when they enter the United States, they would enter as a permanent resident or conditional resident if they've been married for less than 2 years. In other words, the green card would be sent to them when they enter the United States within 2 to 6 months, hopefully, after entering the United States. And they wouldn't have any other steps to do here in the United States unless they had to remove their conditions later. And that happens if you're married for less than 2 years. With the I-130 and I-45, my apologies, this is a typo here with DOS. Everything is done with USCIS. So the I-130 is available if the foreign national partner in the relationship is in the United States. Let's say they're here in the United States in a different visa classification like an H-1B, or sometimes people will come, it's happened over the past year a lot, as you can imagine, where a foreign national will enter the United States to visit their significant other, let's say on a tourist visa or on ESTA, and then basically get caught in the United States. I have a client right now who's they're going through the I-130 and I-45 process, and her return flight has been canceled multiple times. So when she entered the United States, she fully intended to return to her home country, but that's not feasible right now because of the COVID situation. So it's for people who are in the United States at the time of filing, and everything is done with USCIS. We call it a one-step application because you file the I-130 and the I-45 and all the other supporting forms. Like I said, it ends up being hundreds of pages of documents, but you file everything with USCIS in one step, which is why we call it a one-step. Another key difference with between the fiancé visa and the other 2 options, with the fiancé visa, do not, please get married first before you file the I-129F. You can only get married once the foreign national has entered the United States. What does that mean? That means no ceremonies, no like, oh, we're gonna have a celebration. You can have an engagement ceremony in your home country before you enter the United States, but no, we're gonna have a quote unquote unofficial wedding in the United States before I enter. Do not do that, because that could mess up your process. The USCIS or Department of State could think you're actually married and not qualified for the K-1. We've had that come up before for people who have tried to do this on their own and then run into that issue. So do not get married or have anything that looks like a wedding, even if it's not legal or even if it's unofficial. With the I-130 consular processing and the one step, you do have to be married. That's a requirement. I tell people that step 0 is to get married, and then you file the I-130. For all of these processes, you have to be eligible to be married before you file any of these. That means that if you are divorced, your divorce has to be complete before you file any of these first steps. So if it's the K-1, before you file the I-129F, you have to make sure that your divorce is complete. That sounds pretty simple. You're thinking, yes, Emily, I know that I'm divorced. But I have had situations before where a person thinks that they're divorced, let's say in a foreign country, and they're not. And I've had to advise people before we file the I-129F, please go back to your home country, get divorced, and then we can file this. In one situation, I had a person who needed to go to their home country. Actually, I'm not quite sure how. I advised them to consult with a family law attorney in their home country because they had to get divorced, so to speak, from their current spouse, then get actually divorced from their previous spouse, and then remarry the spouse that they wanted to be married to. So make sure that that's straight. And again, that's something that we can help with or advise you to. We don't practice family law in any country, but we can advise you to consult with family law attorneys in the home country to make sure that that's straight. Options for other family members. So who can sponsor? This is a question that we get a lot. Who can sponsor different types of family members? For parents, lots of people want to sponsor their parents. Totally understandable. You want your parents to be with you, whether it's to help with the grandkids or you just want to be with them because you like them. Any number of different reasons that you may want to have your parent here in the United States with you. Only citizens, only US citizens can sponsor their parents. So that means green card holders cannot sponsor their parents. It does mean I've had situations before where a person naturalizes, there's no waiting period. A lot of people ask that, how soon or how long do you have to wait after you naturalize to sponsor someone? I literally have had clients who have naturalized, had the oath ceremony, and then we've had everything ready to go to file for their spouse or their parent or whoever they want to sponsor. And we slip in, we have everything ready to go. As soon as they have the oath ceremony, we slip in a copy of the naturalization certificate and then file. So there's no waiting period, but you do have to be a US citizen. The same thing is true for siblings of US citizens. And for children, it depends. Both US citizens and green card holders can sponsor it can sponsor your child, but the wait time is where it gets interesting. So parents are considered immediate relatives. So there's a quote unquote shorter wait time for immediate relatives, meaning parents, or it's immediate relative also includes spouses of US citizens. When I say shorter wait time, you still have to go through the process. You still have to make sure that, or you still have to have wait for the I-130 petition to be approved and the consular processing or the I-45, depending on where you're filing, but you don't have to wait for the priority date to become current. And we'll talk about the priority date in just a minute. That's very important for siblings, the next category here. Siblings of US citizens fall into the F4 category, and they are considered the lowest preference category. I hate to say that because it sounds like they're not important, but that's how it is. That's how US immigration law defines it, the lowest preference category. So they are the lowest preference category. That means it's going to take years to sponsor, to wait for this process to play out. And we'll take a look at that in just a minute. For children, it depends. It depends on children of US citizens. Minor children of US citizens are considered immediate relatives. Minor children of permanent residents fall into another category. And then there's another category for adult children and whether you're married or not for US citizens and permanent residents. So that really depends. The process, what the process looks like. For a parent, you can do a one-step, meaning they can apply for permanent residence here in the United States, or if they're here in a legal status, or they can do consular processing, meaning filing the I-130 petition and having them apply for an immigrant visa like we talked about on the marriage-based case or marriage-based slide previously. For siblings, it's likely going to be consular processing because they are not, let's say that they're here in the United States on a different visa category, let's say F1. That F1 status is not going to last the 10 to 15 years that it might take to process that. So they might be, you would likely do consular processing, not necessarily. We'll talk in just a minute about if your sibling is in a different visa category. And we have a question on that as well. And then for children, again, it can be one-step or consular processing depending on where they are in the world, whether they're here in the United States or overseas. So we have a question that's relevant to this slide. It's asking about sponsoring a sibling. So this is sibling of a US citizen, and whether that would interfere with them applying for an H-1B or the diversity visa lottery. Meaning, can you do both or multiple options to see which one happens faster? The answer is yes, but typical lawyer answer, right? It depends. So yes, you could do the H-1B or visa lottery and at the same time as sponsoring filing as a US citizen sibling. You have to be careful though, because the H-1B and the visa lottery is a different, diversity visa lottery is a different way to get permanent residence. But the H-1B is dual intent. That means that a person can hold the H-1B status and go through consular or go through the green card process at the same time. That's also true for the L1 classification, which is a different type of temporary visa classification. It's not true for other visa classifications. So for example, if the sibling, I mentioned here, the sibling might be here on F1, which is a student visa, that is not consistent. It doesn't allow for dual intent. If you're here on an F1, your intent can change for sure. But you're basically saying, I'm coming to the United States to study and I intend to return to my home country after I finish studying. You're at least making that attestation when you apply for the visa and then when you enter the United States. So you just have to be careful about what options you might want your sibling to take in the future and whether those options allow for dual intent. And again, I'm happy to talk with people about this because it is a very strategic decision, conversation that you would have to have. But for the H-1B or visa lottery, yes, you can be on either of those and be going through the green card process, family-based green card process as the sibling of a US citizen at the same time. So the visa bulletin, I mentioned on the last slide that with talking about the wait time, it depends on how long it takes. And I said, parents of US citizens and minor children of US citizens are immediate relatives. So there's no wait other than waiting for the process to play out. And I said, for other categories, it depends. These other categories are here. This is the visa bulletin. It is published once a month by the Department of State, and it tells us basically when a green card is available. It's complex. There are immigration attorneys who do not always have a full comprehension of this. It takes time to understand. I'm showing you one table of 4 tables that are on the visa bulletin monthly, but I want you to at least have a sense of what it is and more or less how to read it. So the visa bulletin, as I said, is published once a month by Department of State. There is a limit every year on the number of green cards that are available for people who are interested in coming to the United States. That limit is no country can take more than 7% of the overall allocation of green cards. And we have so many immigrants from China, India, Mexico, and the Philippines that they would take more than 7% if they didn't have their own allocations. So that's why you see those countries separated out. And then everybody else, all other countries are listed there, which says all chargeability areas except those listed. These categories are the family-based categories. F4 is siblings of US citizens. The F2A is spouses and children of permanent residents. And then there are other classifications as well. These dates that you see we call them priority dates. That means that it refers to the date that the I-130 petition is filed. If you see the letter C, that means it's current. That means that a green card is immediately available. So for example, if I had a consultation today with a couple and the petitioner was a green card holder, they would fall into this F2A category. And I would say, if the foreign national is here, I would say, hey, you could, as long as the foreign national is in status, you could file the I-130 and I-45 now because there is a green card immediately available. That's not always true. It changes from month to month. For these other categories, you may see that you'll see that there are dates. Again, these are priority dates. So if you look at F4, siblings of US citizens, and all chargeability areas except those listed, so anybody who was not born in one of these countries, the priority date is October of 2015. That means more or less that it could take 5-6 years for this to be processed. This date is, sorry, I said that wrong. It's October 15th of 2006. I thought it takes longer than that. I read it backwards. So it's October of 2006. So it would likely take 15-ish years for a sibling of a US citizen to be able to immigrate to the United States. And you'll see that the other dates as you go across the chart are longer. Look at Mexico, it's from 1998. The dates do not move in real time. They are, like I said, this is published from month to month. Every month the visa bulletin is, and it is possible that the dates would stay the same next month. It's possible that they would retrogress, meaning go back, or it's possible that they would jump ahead. So it just depends on the number of people who have applied, how USCIS and Department of State are allocating the visas, or rather how many they're using. And there's actually a person, his name is Charlie Oppenheim, who works at Department of State, who gathers all of that data and then puts it into the visa bulletin and publishes it through Department of State once a month. That's another thing that we hope will change. He used to give, he called it check-ins with Charlie because his name is Charlie Oppenheim. He used to give check-ins with Charlie even through the Trump administration, but I haven't seen that recently. So I hope that will begin again because it gives us insight through him. So he's the guy behind, like with the magic ball behind the curtain, who knows more or less what's going on with the number of visas available. When I say visas, I mean green cards. So that was helpful to know what's coming down the pipeline in terms of both for employment-based and family-based. He would say, okay, I think that China, for example, is going to move up 3 months for F2B next month, things like that. That was helpful for planning purposes. Tips for filing. So these are general tips for filing any sort of family-based, really any immigration case, but tips for filing a family-based case. I think my number one tip is to talk to a lawyer, at least talk to a lawyer, preferably hire one. I understand that that's not feasible for everyone for financial reasons, but I think it's critically important because you can make mistakes that you can't undo. And that can affect you for the rest of your life. So I really encourage you, and I'm not just saying this because I'm an immigration attorney, I tell people to talk to a CPA about taxes or, go to a doctor instead of trying to Google it. But professionals are here for a reason. We know what we're doing. I literally dream about immigration a lot of times. And I love what I do. So talk to a lawyer to make sure that you at least have the right strategy. Know that if you have a consultation with a lawyer, different lawyers do it different ways, but a lawyer should not give you detailed instructions on how to do it yourself. I don't do that because of liability reasons. If I were to say, oh, you need forms A, B, and C, and this is how you fill it out, and then you go and misunderstand something or do it wrong, that could come back to me. So And it's a disservice, I think, to the client as well. So I won't tell you how to do it, but I'll tell you through a consultation what strategy I think you should take and outline the general process for you in more detail than what we're doing here. But again, I would hire one if you can at all afford it. I think it pays back a lot. I think it's very helpful. Secondly, be honest. One of the worst things you can do, maybe the worst thing in immigration law, is to try to hide something or not tell the truth. It's like going to the doctor. The doctor needs to know everything, even if you think it's not relevant, because your toe hurting could actually be connected to your head hurting, but that doesn't make sense to us as lay people. So likewise, tell your immigration attorney everything. Tell immigration, USCIS, don't lie on forms. Don't try to cover up something because you think that it's going to cause a problem. Get information first, get a plan, and tell the truth. Document. A lot of times clients come to us, people who have tried to file on their own and they have a denial or a request for evidence, which slows down the process because they haven't, I guess this also goes to check and double check. They either haven't prepared the form properly, and so they've had a denial or a rejection, or they haven't provided enough documentation. And so it actually costs more a lot of times and takes more time if you don't do it right the first time. So make sure that whether you're doing it on your own or through a lawyer, make sure that you submit sufficient documentation. The more documentation in general, there is a limit, of course, to the reasonable amount of documentation required. But make sure that you submit enough documentation, clear documentation, well-organized documentation of your relationship, of your financial situation, whatever it is that you're needing to prove. Be realistic with your timeframes, with the outcomes and with the timeframes. In our office, I always will tell a person if I think that their case will not be successful. With a marriage-based case and other cases as well, I usually will not accept a case. I will not accept a case if I don't think it's going to be successful. There's sometimes where I say, well, I think you might have a problem with this. I think this might come up, and I still will represent them, but I want to make sure that they know what the possible outcomes are. But just in general, even if you have a super clean case and you've been married for 20 years and you have 15 kids together, just kidding, that's not required. But even if you have a super clean case, you still can have processing times that are outside of your expectations. So be realistic, know that the processing times change, know that the USCIS processes and trends change, and just keep that in mind. Speaking of processing trends, let's talk about timelines. I'm not able to talk about timelines for all of the family-based cases. I can tell you that in general, the processing times for across the board for immigration have increased. I think that's due to several reasons. First, because of COVID. So with USCIS has been open. They closed for about 3 months from March to June, but they are trying to have fewer people in the office because of COVID, and they are working from home, which always slows down the process, I think, a little bit. So we're seeing slower processing times in general, not tremendously slower for US-based filings, that is for USCIS-based filings, except for receipt notices and fingerprinting. If you have filed anything with immigration in the past year, you know what I'm talking about here. Receipt notices, or I'd say especially since this past fall, receipt notices are taking forever. Across the board for all types of filings, but especially for family-based cases and for I-485 filings, even if it's employment-based. We are still waiting for receipt notices from October filings, unfortunately, and there's really not a lot of movement on that. They're kind of trickling in, but it goes back to what I just said, is maintain those expectations, make sure that they're realistic. I know it's frustrating. I get it. I'm frustrated too. It seems ridiculous that they can't just, process a case and then send us a receipt notice in a couple of weeks, but that's where we are right now. They say that that's due to COVID. The receipt notice issue is due to COVID, and they have reduced staff in the mailrooms. They've also had an increase in filings, I believe, I would imagine, because in October, the USCIS filing fees were supposed to increase. You may remember that was regulation was set aside by a judge, and the Biden administration has indicated they're not pursuing that anymore. at least for now. So, but anyway, that I would imagine increased filings. And then in October of 2020, you may know the employment-based green card process opened up, so lots of people could file who previously could not. So there was an uptick of filings there. Likewise with fingerprinting, they are very behind with that. In December, USCIS announced their 1.3 million fingerprinting appointments behind. So sometimes they're being canceled. They were canceled because of COVID, obviously earlier in the year. We've had some cancellations because of weather or because they closed all of the USCIS offices for the inauguration kind of at the last minute. So if you haven't received your fingerprinting notice, or if you had it, but they canceled it, it should be rescheduled automatically. They are asking for patience. USCIS is asking for patience with fingerprinting. Our office is placing service requests and following up with USCIS for fingerprinting if it's been beyond a time frame that we're seeing for other clients for that particular filing location and type of case. So if you are a current client and you have a question about that, feel free to send us an email, and we're also looking at it. But that being said, we're not following up if it's still within USCIS's long time frame, anticipated time frame. With consular issues, going to timelines, consulates around the globe have not been open because of COVID, supposedly. They have not been as transparent about their timelines for reopening, and it's done on a post by post basis. So with USCIS here in the United States, it's been pretty consistent. They consistently all of the offices were closed, and then they reopened. They kind of took a little bit, a week or so to reopen, kind of in a staggered way in June, but they pretty much reopened as of June or July of this year. And we had information on that. They said we're closed because of COVID and we hope to reopen as soon as we can. And then they gave us a heads up. So that was nice. That is not happening with the consulates. Department of State has been pretty silent on what they're doing on their closures. And it's been frustrating. We don't know exactly when they're going to reopen. It is more complicated, obviously, because they're in different countries and they're different country conditions, and they have to look at the CDC guidelines as well as the in-country guidelines. So it is more complicated. We're seeing that consulates in East Asia are generally open. We're having people process out of the Philippines, for example. Other consulates are totally closed. Western Europe, we're not having them process at all. Latin America, we're not seeing them process at all. So it is a case by case or post by post basis, but we're really not seeing a lot of movement. I tell you that because there's going to be a backlog, both with K-1s and with immigrant visa interviews. There is a backlog. So whether you're starting the process now or whether you started it previously and you're waiting for the consulate to schedule the interview, it is going to be a while probably before the interview is scheduled, because the consulate has to reopen and then they have to work through that backlog. And we don't know exactly how long they're going to take to do that, of course. Hopefully it will be sooner rather than later, but we'll keep everyone posted on that. The other thing I want to mention in terms of consular issues with the K-1s, you may know about this depending on how involved you are in the K-1 scene, but the K-1 again is a fiance visa. The proclamation 10014 that I mentioned that was issued in April by the Trump administration did not specifically mention K-1 visas. It mentioned very specific categories. It laid out very specific exceptions, was silent on K-1s. So as immigration attorneys, we thought, okay, they didn't mention it, so they must still, to the extent that a consulate is open, they must still be processing them, and maybe we can get emergency appointments. That has not been the case. The Department of State, for various posts across the world, we and immigration attorneys across the country have advocated on behalf of our clients, followed up with a consulate, asked, when are you going to schedule the interview? Here's our situation. Can you please schedule? And they have said no. And a lot of times they either didn't respond at all to our emails. And again, this is not just our office, it's everybody, all immigration attorneys across the country. They either didn't respond or they said, we're not scheduling K-1 interviews because of the proclamation. Sometimes they would say our consulate is closed and use that as the reason, or give that as the reason. But bottom line is Department of State hasn't come out with a directive saying we're not doing this. They have come out, we're not scheduling K1 interviews, but effectively they have not been. And they, I believe, were given a directive that was not published to say that we're not scheduling, a directive from the administration, the previous administration, to say we're not scheduling K1 interviews. We don't know exactly what's going to happen with that, because it's not written anywhere. What, like I said, it wasn't in the proclamation. The Department of State since then has said, they issued, actually, I think it was back in August, they issued a statement saying that they would proceed. The Department of State has been authorized to proceed with K1 visas, but we still haven't seen movement on that, and it's been months. There has been a lawsuit, Mulligan versus, I think it was Department of State, and those plaintiffs and that lawsuit for K1s have been successful. We have firsthand knowledge of claims that have been successful in that lawsuit, but it only benefits the plaintiffs in that particular lawsuit. So no, if you're thinking of the K1 process, hopefully, if you're starting the process now, hopefully it'll be resolved by the time you get to that stage, but know that that's an issue. Still, currently it's not resolved, and they're going to have a backlog of K1s to work through. So that's not a super happy issue to end on. So let's talk about communication and transparency with the agencies as our last topic, and then I'm happy to answer any questions that we might have coming in. The communication and transparency with the last administration, the Trump administration, was not great, as you can imagine. Before the Trump administration, we didn't know how good we had it. We had communication with the agency. So that means we had liaison meetings. I'm a member of the American Immigration Lawyers Association, and also called AILA as an abbreviation. AILA had meetings, regular meetings, liaison meetings with different agencies. We had regular liaison meetings with the local USCIS field office in Norfolk. And we had email access to the Norfolk local office. We had ways to communicate with USCIS. We couldn't call and talk to the officer. That's never been a thing. But we could schedule InfoPass appointments, or clients could, to talk to an officer about their case. All of that was cut off with the past administration. That has not changed yet, but we are seeing signs that that will change. And I'm hopeful that will change in the current administration. And hopefully processing times will improve, and just administrative issues will improve. You know, this issue of issuing receipt notices in a timely manner will improve with the current administration. As I said when I first started speaking, Mayorkas is head of the Department of Homeland Security. He was previously interim director of USCIS, and as an immigration attorney group, as a bar, we thought he was great in general. You know, nobody is perfect, of course, but he seemed to really implement efficiencies into the agency, seemed to promote open communication with the stakeholders, meaning you as foreign nationals and us as attorneys. So we hope that that will come back to USCIS, and that it will be at least a more pleasant experience. Not that they're unpleasant people, but that we'll have more communication and transparency as to what's going on. So that is the information that I have. If anyone has other questions in addition to what has already been asked, please feel free to put that in the box here, and I'm happy to help. Ways to stay updated. Things are still changing all the time. I don't know what your perception is, but I know my parents are like, oh, Emily, Biden's in office now. Isn't everything better? I'm like, well, it's getting there, but it's still crazy. There's still lots of changes all the time. So you need to keep up with that to know what your options are, to know how your case might be affected. So ways to get that information from our office are to read our blog posts. We post blogs regularly on our website, which is being updated and will be refreshed this week. So blog posts, check out our blog posts. We publish a newsletter once a month, the first Wednesday of every month, and you can sign up again on the homepage of our website. And then RSVP to future webinars. We tend to have these webinars once a month on different topics. If there's something, you know, breaking information, like when COVID hit, we had information about that. And then when the travel bans came out, the COVID related proclamations, we had information on those. So it can either be topic specific if something specific is happening, or just in general, ask an opportunity to ask questions and get direct access to me. One question is, with the travel ban on South Africa, is there a way to speed up an F3 for a person that is on a different visa in the US from South Africa? So it depends on, in general, no. So with the proclamation that's in effect, or the COVID-related travel ban in effect for South Africa, is related to COVID, like I said a minute ago. Ways to get around that are either to quarantine in a different country, or to ask for a national interest exception. So yes, the answer is yes, but it's not straightforward necessarily. Is it true a green card holder cannot sponsor a spouse if they received their green card and have to become a citizen first to sponsor? Not necessarily. A green card holder, let me read this again. Is it true a green card holder cannot sponsor a spouse if they receive their green card? So there are restrictions. Yes, that's a great question. There are restrictions on sponsoring a spouse if you, yes, became a green card holder through marriage. Yes, you would have to become a citizen first. That's a great question. Fingerprinting timelines. Mine got canceled the last week due to the weather storm. I don't have specific timelines for you because they're taking, like I said, forever to reschedule. They say that they will reschedule fingerprints automatically. I would say if you don't have a notice for a rescheduled appointment within a month or 2 months, to place a service request to see if you can have it rescheduled. And that's important because you want to have documentation to show that you've attempted to reschedule. You don't have to do it immediately. Give them a chance to reschedule. I think that's fine. But you don't want months to pass and it not be rescheduled and then them deny the case because you were never fingerprinted. You wouldn't, if that did happen, you would want to have documentation that you were proactive about it. I know that's really frustrating. Soon to be expiring passport, impact I-94 date if H-1B gets approved this time. So this is an H-1B question. I'm going to go ahead and answer it. And I will wrap up. I know people have to go. I'll wrap up at 1 here. But yes, you can use you can file with an H-1B petition as long as your passport is valid. I have filed before. Talk to the immigration attorney handling your case, which is probably me. So talk to me in detail. But I have filed before with a passport that's going to expire. And then we've gotten an RFE request for evidence and then have submitted the new passport. It's not a problem. If it's an H-1B cap registration, it's fine to register with, it should be okay to register with the expired passport, but email me directly and I'm happy to help. Biometrics, are you seeing biometrics reused for your clients? And what is the timeline for I-751? Do you think it could be shorter? No, I do not. So for I-751, and this is, the I-751 is the petition that you file to remove the conditions if you've been married for less than 2 years. That has taken forever. By that, I mean 2 years to be processed, for a long time, for years. And I don't know why. I guess they just, priority-wise, it doesn't take priority, but I don't anticipate that changing. I hope to be wrong. I hope that they change that, but no, I don't see that changing anytime soon. Yes, biometrics are being reused when they can. They started doing that during COVID, which has been nice. And you should get a notice either online if you're signed up through the My USCIS account or by paper if they're able to reuse the biometrics. If there are questions that I did not answer, then that you submitted by registration, then they were probably too detailed to talk about in a setting like this. So feel free to set a consultation if I did not address it, and I'm happy to help you walk through that. Otherwise, I'm going to wrap up now. In addition to these resources, we also are on social media on Facebook, Instagram, and LinkedIn, especially my personal Emily Sumner LinkedIn, also our company page, but I tend to post more on my direct page, updates, immigration updates. I want to thank you all for joining us. I hope that you will join us again. I hope you found this helpful. And like I said, we have recorded this and we'll send it to everyone who registered. Have a great day. Bye.